Following a petition written to the Chief Justice of Nigeria, Justice Kudirat Kekereekun, the National Judicial Council may invite Justice Peter Lifo of the Federal High Court in Abuja and his counterpart in the Rivers State High Court, Justice I. Igwe, to explain themselves in respect of contradictory and conflicting court orders issued to the Independent National Electoral Commission and security agencies regarding the just concluded local government area elections in Rivers State. While Justice Igwe, in a suit brought by the All People's Party, had ordered INEC to release the voters' register used for the conduct of the 2023 general election to the Rivers State Independent Electoral Commission for the purpose of conducting local government elections slated for October 5, Justice Lifo, on the other hand, ordered INEC not to release same register to the RSEC until it has been updated. Similarly, while Igwe in the September 5 judgment ordered security agencies to provide security during the LG polls, Lifo had ordered the contrary. The two conflicting orders led to a near breakdown of law and order in the state before and during the elections. Joining us now on the show to review the conflicting judgments of the Nigerian judiciary is Liberos Oshoma, a lawyer and human rights activist. Good morning and welcome to the morning show.
Good morning.
Liberos.
Yes, sir.
This has been an old problem.
Yes.
Lawyers shopping for forums.
Forum shopping.
Misbehaving as officers in the Temple of Justice. But when Justice Kudirat Kekereekun appeared before the Senate panel that confirmed her appointment and during her inauguration as CJN, she said she would tackle indiscipline in judiciary, also as chairman of the the National Judicial Council. Now, to what extent is this situation in Rivers State with the conflicting and contradictory judgments between two courts of coordinate and co-equal, jurisdiction, a litmus test for Justice Kudirat Kekereekun's avowal that indiscipline will be dealt with?
This is, she's not the first CGN that he's saying to tackle indiscipline in the bench. She's not the first and she's not going to be the last. For me, these are mere rhetorics because the problem is endemic. It's a systemic problem, and Nigerians generally are good people. But when it comes to politics, we just completely threw it away. We lost it. Everything that politicians touch in this country, you see how they completely destroy it. And so, the only way you can solve this problem is when you remove pre- and post-election matters from the courtroom. Politicians will no longer be interested in what happens in the judiciary. Let me take your mind back. Why, before now, by the provisions of the Constitution until it was amended, governorship election petitions used to end at the Court of Appeal. What led to the Supreme Court saying, bring them? Because they were giving conflicting judgments. Court of Appeal on the same set of facts in Port Harcourt will give one judgment. On the same set of facts, the Court of Appeal in Kaduna will give another judgment. As far back as 1992, if you remember the Justice Ikpeme, famous order restraining the conduct of election. If you read Shegu Adeniyi's book, yes.
Politics, People and Power?
Yes, Politics, People and Power. He said that some of the governors that gathered in Nikon Nuga then were calling their own CJ in their various states to also issue contrary order to the order issued by Justice Ikpeme. Also, recently when you hear a court in, was it in Edo State? Or no, a court in Abuja granted an order removing the national chairman of APC, Oshoma, from office. Immediately, another court in Kano granted a contrary order. In 2015, when the fight of the soul of PDP was at its height, today we'll hear an order from Abuja, just like we're hearing now. The very next day, a conflicting order from Rivers State Federal High Court, Federal High Court. And it was advised that the Federal High Court should have a docket, an electronic docket, that once a matter is filed, before that matter is assigned, that there should be need to reconcile the fact of that case by the admin judge to know if a similar matter had been filed. All of those were said, and even the CJN then, during screening, also came out to say, we will ensure that we rein these people in. And at the end of the day, what happened? So the problem here is the fact that anything that the politicians touch here, we always see the decay and the rot. Because look at Abuja, Federal High Court in Abuja, State High Court in Port Harcourt, Federal High Court in Abuja, State High Court. It is the same ping pong with the lawmakers in, in Rivers State. The Federal High Court in Abuja will give a judgment today. The very next day, the State High Court in Rivers State will give a conflicting judgment. Even in matters where they clearly do not have jurisdiction to determine. So it is a matter of interests. And the lawyers also, Justice Kayode Esho once said, behind every allegation of bribery against a judge, there's a senior advocate who's a conveyor belt. This coming from late Justice Kayode Esho at that height. So it is not a novel thing. It is not something that will pretend that it's just happening today, and so the CJN will just sit down and say, okay, henceforth. The governors also control judges in their state. We saw what happened in Edo State. Governors control judges the way also by the federal. We also see, those people at the federal also have influence on judges.
This then brings the conversation around the independence of the judiciary. I say this because, like you've mentioned, where governors, presidents can have such influences on them, then it's difficult to say that they shouldn't be partial in certain regards. And so I just want to speak, because that's a conversation that's also ongoing. Can we have that transparency, that restoration of the institution, as you've talked about, without having the independence of the judiciary?
I was a moderator at a seminar recently where we had both retired senior judges and 7 senior judges, senior advocates, and I put this question to them. And the answer was, it depends, like we say in equity and trust, it depends on the chancellor's foot. It depends on the mindset of the judge. But in a case where even the appointment of judges is largely and highly politicized and influenced, and so because politicians are interested, they know that these people will determine whether they stay in office or not. So the first step is, no, we want to influence who gets there. They look at Edo State. I always go back to Edo State, where judges were appointed, screened by the State House of Assembly, screened by, approved by NJC, and the governor said, no, I will not swear them in, for reasons best known to him. So these are some of the challenges. And so some persons, politicians, have also muted the idea. I listened to Shehu Sani, and he said, look, you need to find a way to remove this politics, the determination of pre- and post-election matters from the court. Once you're able to do that, then this unnecessary interference will no longer be there. But as long as the judges will have a say in who becomes, who occupies any office, we're always going to have all of this. And another thing is, even the appointment and nomination and the dismissal of judges, remuneration also, is something we clearly need to look at. How do we ensure that this is also not domiciled within the ambit, apart from the NJC, which sits on ad hoc basis anyway? We also need to find a way that it is completely removed and insulated from the hands of politicians. Otherwise, you're going to consistently have this issue where a chief judge of the state will be summoned. If you remember, the, El Rufai's book, Accidental Public Servant, he wrote it there clearly that when they wanted to revoke lands in Abuja, he summoned the judges and said, look, this is what we're going to do, but ensure that you do not grant frivolous court orders against us. It's right there in his book.
Okay. How quickly can we get that electronic docket that once you put a judgment anywhere in Kutowenji, it shows on the server, that shows every other person as regards that case? Secondly, do you think Justice Kekere can actually surprise most Nigerians by enforcing, what it has to be as regards the law? Thirdly, as regards these cases of conflicting judgments, do you think also that the CJN should not be the one to hear these cases? There should be an NJC that is independent, that is composed of various societal groups.
Right. Let me start from the last. I would, as I remember, the last. If you look at the constitution here, the appointment of members of the NJC, about 85% of the members are appointed by the CJN. The 5 members of the NBA, who, in the opinion of the CJN,
should we take that away?
Yes, we have consistently said that when you say that the NJC, look at the crisis between Justice Kasinalu and Justice Ayo Salami. He went that way because the NJC, about 85% of the members of the NJC are appointed by the CJN. And so if you have a problem with the CJN, and then you have people who are appointed by him determining, and yet we say in law that nemo judes in casesua audiotarem patem, no man shall be judge in his own case, and you must hear the other side. And here indirectly, you are judging your own cause. So on that note, there's need for us to remove that powers from the CJN. And then coming to the issue of the docket, you can do that with practice direction. You don't need a law, you don't need constitutional amendment, even segmentation of the court that the states do, they do it with practice direction. So it is an administrative procedure that the court can, the chief judge can take into cognizance, and boom, that will be achieved. Even in Lagos State, the fast tracking that have been achieved in Lagos State and all the electronic innovations, you don't have it amended. All of these are true practice directions.
The most important question: do you think Justice Kekere can surprise us?
I wish her well, and I have known Justice Kekere right from her days as a judge in Lagos State. Here, she's somebody who, when she wants to achieve something, she goes all out. But
what do you mean by when she wants to achieve something? Is that she doesn't achieve something every time? What do you mean by
when there's a responsibility on her to achieve something? But the problem here is that there are forces beyond the CJN. I just told you about anything that politicians touch. There are forces beyond the CJN that might not want to see all of this. It is like committing a class suicide for the politicians.
We need to round up. But before we go, in less than 1 second or 1 minute, you mentioned the word jurisdiction, which is at the heart of the justice administration process. Between the High Court in Rivers and the High Court in Abuja, which one will you say has jurisdiction?
Let me tell you what they have cleverly done. You drag INEC, being a federal agency, into the matter. And then you say, being a federal agency, and since the court had been heard, the Federal High Court had been heard to have one jurisdiction, so everybody goes to Abuja. And so since INEC is a federal agency, you say, yes, INEC has, the Federal High Court in Abuja has jurisdiction, being a federal agency. And then also, being a state's electoral body, also, you drag the River Sec into it, and then you come to Port Harcourt. So the lawyers are clever. So indirectly, what they do, they forum shop, but they know what they actually want to achieve.
Thank you very much.
My pleasure.